Attorney Brenton Begley here. I'm an attorney and partner with McIntyre Elder Law, and let's answer the question as to whether or not it's too late to attempt to do long-term care planning. So I want to dispel any notion that long-term care planning must be done years, months ahead of actually going into a facility. Now, ideally, you would plan years ahead for something as important as protecting your assets from the cost of long-term care. And a lot of people don't do that sort of planning, and it's understandable because a lot of people don't understand the risks that they face. They don't understand that over 70% of individuals will need some type of long-term care at some point in their lives. They also fail to understand that because of that 70% chance, they're facing costs of $5,000, $10,000, $15,000 a month to pay for that long-term care. So certainly understandable why folks don't do the pre-planning. But let's imagine that you're in that position where you haven't done the pre-planning. What can be done to help protect you? Well, at least sitting down and knocking out the low-hanging fruit is going to be incredibly important. So first of all, avoiding probate. That's one of the main risks to folks' money and property. So in North Carolina, probate is the only opportunity for a creditor to come after the estate. And that's what we're really concerned about with long-term care. So you start to incur costs through long-term care. The question is when can they come in and take assets? A lot of folks think that a nursing home can just come take your home. That's not the case. You can keep your home, still qualify for benefits to pay for long-term care. You can keep your home, still go in a nursing home. It's just that if you incur a substantial medical debt, they can come take your home if you pass away and that home goes through the probate process. So probate is a default process. You can set any of your assets up to avoid this probate process. If I pre-designate an asset, I can have it automatically passed to a loved one upon my death, like naming a beneficiary on a life insurance policy, naming a beneficiary on a bank account. That's a pre-designation. If I don't do that, there's got to be some way that I can get the asset that I own from me, if I die, to my heirs. So who facilitates that process is the probate court. So basically, if you do not have an asset pre-designated, it must go through probate. We want to avoid probate because it's a long, difficult, and expensive process, on average 6 months to 2 years to get an asset from a loved one who passed away to the heirs. So that not only is it a long, difficult, expensive process, but it is the only opportunity for a creditor to make a claim against the estate. So if there is a creditor, if you racked up any medical debt, incurred any medical bills, you had to pay the nursing home or got a benefit like Medicaid to pay for long-term care, they can come after those assets if you pass away and allow the assets to go through that probate process. So we really want to set assets up to avoid probate. It's one of the first things that we need to do if we sit down to talk as a part of this plan. Another one is to make sure you have power of attorney in place. If you don't have power of attorney, then you lack the ability to do most of the things that may need to be done to move around assets and protect them if you cannot do that for yourself. If you're in long-term care, if it's a loved one, you can't act on a loved one's behalf without that power of attorney, move around assets and have access to the assets that are there to protect them. So power of attorney is incredibly important for that reason. And then lastly, coming up with a plan to get qualified for a benefit to pay for long-term care while keeping and protecting what you have, that's incredibly important. Now, I can't go into detail is exactly how that's done. It's very, tailor-made to each client, each situation. But that's something that you need to sit down with an experienced elder law attorney and do if you are in need of long-term care, if a loved one is in need of long-term care. We do that and we'd love to help. So if you find yourself in the situation where you're wanting to plan for the risk of long-term care, or if that's an imminent threat to you right now, then give us a call, 704-259-7040, or visit our website, mcelderlaw.com.